Hello, everybody. This is David Warren. I am a co-founder of Bridgeford Trust Company and chairman of the board. Very excited to be talking to you all today. I know you're in a couple of days of great sessions, and I hope to make this one another part of that. We're going to be talking to you about a topic that I am particularly excited about, and so is Bridgeford, and it's one of the reasons why we founded Bridgeford, and it's modern trust law. You know, we're going to talk about modern trust law concepts that have become powerful planning tools, particularly in the uncertain times that we're kind of living in. You know, regardless of where we are in the COVID cycle and the fact that, you know, we're coming into an uncertain time relative to what's going to come out of Washington. The reality is there still remains tools that can be very, very powerful in an uncertain time. And throughout the next 45 minutes, we're going to go through some very exciting topics that we use regularly at Bridgeford under South Dakota law and under the law of progressive and top tier trust jurisdictions. I certainly welcome questions and look forward to the opportunity to interact with all of you. And you know, this quote really struck me through the pandemic and really as we approach what's happening here in Washington. There's lots of different stories of what may happen. Some people think that Bernie Sanders and Elizabeth Warren are going to take over the tax code, and everybody's going to socialism is going to happen. I don't think that's going to happen, but certainly change is coming, and certainly there is uncertainty. And this quote by Bono is one of my favorite artists. It says something I think pretty prophetic, which is uncertainty can be a guiding light, and I think that's absolutely true. I think that it propels action, it motivates movement, and it forces us to get creative and to find solutions. And so what we're going to talk about is really an old versus new paradigm in the world that we're navigating in the trust space. And it's important to juxtapose the two as we launch into a discussion of modern trust law. And that is because really to understand what's different today, we have to sort of define what it was yesterday. And what it was yesterday, and still exists, but in my mind it's old, is the idea of a trust that has to end at a certain time, triggering a state tax. The idea of trusts that are bundled together with respect to trust administration, asset management, private banking, deposits. This is bundled approach that you see at Bank of New York Mellon or JP Morgan or PNC. That's an old paradigm that is being broken apart by the new paradigm. This idea versus delegated and directed. We'll talk about a lot today, the directed trust, which you'll hear me say a few times, I believe is really one of the bedrocks of modern trust law and what has really revolutionized the industry. The conflicts of interest that exist in the old paradigm and the old trust space with the bundled approach are unescapable, and something that was one of the reasons, quite frankly, why we founded Bridgeford, was to address that. Asset management, a lot of bank trust departments, they are trust companies because they want to manage money, not so much because they want to be trustees. I think that paradigm has been broken apart. Rigid and inflexible, expensive, poor service. These are the things that we would hear about the old paradigm. These are the things that I would hear of complaints of the old bundled approach paradigm. And from that was born a new paradigm, which is, of course, unbundled, removes conflicts of interest, the ability and interest to hold non-traditional assets like closely held stock and real estate, direction and control. To me, that's goes along with the directed trust and is what is really revolutionary about what we're able to do now in a new paradigm. Much more cost efficient and a boutique approach to service. And really what I love about this, and really I think all of modern trust law, which frankly didn't exist when I was in law school. So it could be why I didn't like trust in the States when I was in law school. And it's probably amazing to my friends and family that I've grown up to own a South Dakota trust company. But nevertheless, the point is, what is so incredible for me to have watched over the last 20 years is this new paradigm came about because really of just a real unhappiness with the traditional system. Wealthy families from around the country said, no, you know, we don't want trust to have to end after a certain measurement of time. We're tired of conflicts of interest. We want more direction and control. And from that, from an industry response is born the new paradigm ushered in by modern trust law. And I think that from our perspective, finding certainty in trust situs selection is the most compelling aspect of modern trust law. And what I mean by that is, you're going to hear this throughout the next 45 minutes, is that, you know, where to put a trust is extraordinarily important. And there's been this race in the United States as to, among certain top tier trust jurisdictions, to be the best. And Trust and Estates magazine and Steve Oceans and various other experts around the country have really identified 4 or 5 states that they consider top tier, that have the most modern and flexible trust laws, the best asset protection, and those are topics we're going to explore in more detail. So of course, South Dakota, Delaware, Nevada, Alaska, you hear a lot about them. That has been the focus for many years. And then there's Wyoming. Wyoming's been talked a lot about. I put a question mark there because I'm not so sure that it belongs in the top tier, and we'll get to that soon. But really, I think that we, as an industry, a trust industry, can trace the birth of modern trust law back to 1983, where, I'm sorry about this, 1983, which is really the first state in the country to have abolished the rule against perpetuities. And before we get there, I do want to comment on this quote. This quote was very much a guiding light for Bridgeford, and is something that we're very passionate about still, which is, and as I mentioned earlier, this idea of choosing the correct trust jurisdiction is critical, and maybe as critical or more critical as a decision to create one in the first place. And so I found this quote way back in the beginning of Bridgeford when we were applying for our charter. It really resonated with me. And again, it drives this conversation today, which brings me back to the birth of modern trust law, which is, again, in 1983, South Dakota was the first state in the country to abolish the rule against perpetuities. And again, it seems to me that that is the birth of modern trust law. And very simply, we don't have to be an expert in the rule against perpetuities, thankfully, because it's a very complicated rule. The good news is that it's going away in a lot of states. But what it has done is cleared the way for the concept of a dynasty trust, which very simply means that it lives forever, and means that it cannot ever, or when I say it, the assets of the trust, the corpus of the trust, cannot be taxed at the federal level by a forced distribution of assets. It's an extraordinarily important planning tool that families from all over, not only the United States, but around the world have been using. And it's something that, again, in my mind, has kicked off modern trust law as we know it. I want to comment a moment on state constitutional issues. So many of you listening may know what a dynasty trust is. You may say, sure, David, it's you may think it's revolutionary, but it's been around since 1983, and that's fine. But the devil is in the details. I'm gonna say this multiple times in the next 45 minutes, and that's just because the state has a dynasty trust statute does not mean that it's created equally. Some states have constitutional issues, and I'll give you an example. Out of Nevada, which is considered a top tier trust jurisdiction. There's some that say that under Nevada's state government, or rather state constitution, they were not allowed to abolish or amend the rules against perpetuities. Whereas in South Dakota, there was no prohibition on that. And it raises questions in states like Wyoming and Nevada and others that have tinkered with or otherwise abolished the rule against perpetuities. Are these trusts really enforceable? Are they really dynasty trusts if in fact the statute that created them is in direct contravention of the state constitution? That's an unanswerable question. It was a big topic a couple of years ago. At Heckerling, there has not been a challenge. But I think, again, as we're comparing these jurisdictions, it's important to know what we're talking about and what the nuances are. And so, in terms of this idea of using modern trust law, and particularly states that don't have a state income tax, this is where, again, modern trust law has become so compelling and underscores so dramatically, particularly in this context, just how important it is to choose the correct jurisdiction. Because what I'm about to show you and talk about is there are potentially compelling state tax savings just by virtue of taking a trust out of California, for example, and putting it into a state like South Dakota that does not have state income tax. And so just by simply choosing the correct trust jurisdiction can make a huge difference. And in one of the areas that to me is particularly exciting now, because we have case law that supports the theoretical and what practitioners thought was the case, is this idea of a resident trust. And a resident trust simply is a trust that's established in a jurisdiction outside of the home state. So the settlor or the beneficiary may be in a state like California, for example, but the trust is governed by the laws of South Dakota or Nevada or Delaware. And again, those states do not have, right, state income tax. So by virtue of choosing the correct jurisdiction, you can avoid taxation. But taxation on what is the question? Taxation on undistributed income that has not moved or left from the trust. So for example, if we have a $50 million trust and it's sitting in a trust in a jurisdiction like California, and it's just growing, and that's the idea for a lot of these dynasty trusts. It's intended to grow over years and over time. Well, in states like California, if it's governed by California law, the state of California taxes undistributed income. So if you as an asset manager or you as a financial planner have grown the assets in a given year and you've grown it by 10%, well, 10% of $50 million is a lot of money for the state of California to be taking. Particularly since it's never left the trust and it hasn't benefited anybody except for the trust itself. So this idea of the ability to move the trust from California into South Dakota or Nevada to avoid that becomes particularly compelling, particularly over time, particularly in a dynasty trust. We have to be careful here in terms of distinguishing between sourced and non-sourced income. Sourced income, of course, is any income that's derived, let's say, in a state like California. Either through real estate or a business, an ongoing business in California. And that's fine, but trusts often hold investable assets, and investable assets are not considered sourced income to any state, anywhere, because frankly, the assets are domiciled nowhere. They're in the cloud, they're in a computer somewhere. They're not tied to any state or really any country for that matter. So the courts have consistently found that that's not sourced income, and undistributed income earned in an investment account that's in a trust that has been placed in a jurisdiction like South Dakota and Nevada that does not have state income tax, that the assets or that income cannot be taxed by the state. And it has become very compelling, particularly in light of case law across the country, and a case that we're particularly excited about at Bridgeford that was heard by the Supreme Court. Actually, two cases were looked at by the Supreme Court a couple of years ago. But across the country, there are 4, 5, 6, 7 cases that hold that it's unconstitutional for a state to tax undistributed income of income derived inside of a trust that has not been distributed. And it's all generally based on the same principles: a violation of due process, and it would be a violation of due process and a violation of the Commerce Clause. But then comes along a case out of North Carolina, that really was exciting in our industry, and it really set the stage for answering these questions definitively at the highest court in the land, by the highest court in the land. And of course, the case, of course, is called Kasner. And there's also a case very similar called Fielding. Now, Fielding was denied cert, but it gives us guidance. Particularly as does Kasner. And I will say, parenthetically, Kasner and Fielding were the first, I think, 2 tax cases that the Supreme Court had looked at in over 50 years. So it was really a big deal. Bridgeford got involved with funding and helping to fund an amicus brief in support of the taxpayer. And it looked at the issue, excuse me, that I already mentioned about the constitutionality of a state like California or New Jersey or New York taxing undistributed income, and it came to the same conclusion. It held the lower court was correct, and it indicated essentially that Minnesota, well, that's the Minnesota case, that's Fielding, but out of the new North Carolina case, it made it clear that just having a settlor or a grantor or a beneficiary, both cases stand for the same premise. That's not enough to establish proper nexus for purposes of taxation. Now, you might be thinking to yourself, well, David, that's a lot of words to prove what point. The point is that we've gotten to a situation where we now have definitive legal support, case law support across the country and at the Supreme Court that makes the point choosing the correct jurisdiction is vitally important and something that we need to look at extremely carefully. Another tax planning strategy that we've seen, and we've certainly embraced, Bridgeford was involved with one of the first private letter rulings to look at this that examined South Dakota law, and it's basically built on a domestic asset protection chassis. And essentially, how this works, and in the right circumstances, it works in a very compelling way. Is that the incomplete non-grantor trust sounds exactly the way it's titled. It's an incomplete gift, which means there's no gift tax. It's non-grantor status, so the income's taxed to trust level. So let's talk about an example of where this works and how it actually works in the context of saving money to the taxpayer. We take an example of a $20 million potential gain. And again, as you can see, where this is compelling is to avoid capital gains, is to avoid state capital gains. You have a $20 million potential capital gain. We transfer the stock into an incomplete non-grantor trust in a state that has no income tax, no gift tax consequence because it's an incomplete gift. And that's what is looked at by the IRS, I should say. That is what is very important to the IRS in terms of whether these gifts are really incomplete. And there are hundreds of PLRs on this, and we've been involved with several of them, and there has been no negative treatment of this as I'm aware of. Now, you assume a state like New Jersey that has about a 6% income tax, that's a pretty compelling savings. Now, if you think about California, which is double that or more, then this potential tax savings to capital gains level is astounding. And then when you go back to the idea that I mentioned before, well, if this undistributed income, total undistributed income, is a modest 4%, then we have an additional savings of $34,000 or $38,000. So that's a strategy that works. Now we've talked about two strategies that work for the one simple reason. And what is that? Selecting the proper trust jurisdiction. It sounds so simple, but it's amazing to me how many times we miss the opportunity to do that. Another very new modern trust law in the tax space is this idea of a South Dakota community property trust. Two other states have a community property trust. Statute, South Dakota's is the newest, and some commentators say is the most progressive. And it's just, again, it's simple. It essentially treats property, regardless of where it's been contributed from, what state it comes from, where I should say where the settler is who contributes the property. It places or turns the property into community property for purposes of taxation. And the compelling aspect of it is, of course, is at the first to die, there's a 100% step up in basis. That's, again, I use the word compelling a lot because this is very compelling. And so the interesting thing about this is that there are people who say, well, but David, what happens if I'm in a state that's not community property? How does this work? And it works well, and it works for the same principles because the property is owned by a trust that's governed by the laws of South Dakota. And that's why it works. And it works, in my view, under the same constitutional principles as the other issues that we've discussed. So now we have three very exciting, in our view, tried and true, I will say, because we've seen this for years now, tax strategies, all because we've chosen the correct trust jurisdiction. And that's why this is such an important conversation. And why we like to talk about it so much with our families. And so when we transition into more of a discussion of other modern trust laws, I want to pause a minute and sort of recap. I mean, what we've learned or what we've seen, and so many of you may already know these strategies, some of you may not, but what we see is simply by choosing the proper trust jurisdiction, we can save, state capital gains tax, we can save on undistributed income taxation, and certainly the marital property opportunity. And so I think for us at Bridgeford, and for me particularly as a former attorney, the fact that this is so simple to do this is excellent for planners. And it raises a question that we'll talk about later in the presentation, which is, well, at some point, when does it become, and I'm going to say a dirty word here for a second, when does it become sort of malpractice if a practitioner doesn't suggest that simply by moving a trust into a no tax jurisdiction, you can save some money? I mean, I think you can measure damages if somebody doesn't give that kind of advice. And there's some suggestions out of a Harvard Law Review article years ago that said that we could be going in that direction. And there's actually a case that we'll talk about later that raises a question as to whether or not we have a fiduciary duty to do these things. So there's no question we're living through the COVID crisis, and there's light at the end of the tunnel, clearly, thankfully, and an inescapable reality, however, is that a lot of these states that I'm talking to you about today, even top tier trust jurisdiction states, have been hit so hard because they've had to rely, or not they, but their citizens have had to rely so heavily on safety net programs to help them get by. And thankfully, states were able to do that in the federal government, and it was actually amazing to watch how all this came together so quickly. But there's a consequence, right? I mean, unlike the federal government, states can't print money unlimited in an unlimited fashion. So states have been hit particularly hard. And one of the things that we talk a lot about at Bridgeford and with advisors that we work with around the country and around the world is the factors in determining what is the best trust jurisdiction in South Dakota. And we will, in the United States, and we will get there at the end of the presentation. We have a chart that we're going to go through together. But there's another piece of it now, which is a state's fiscal soundness. And objectively, and I'm going to show you the factors, South Dakota has entered into and is evolving out of the COVID crisis is by far one of the strongest jurisdiction from a fiscal soundness perspective. And it looks at a myriad of factors. South Dakota didn't shut down. And we understand it's a small a small population state, but the reality is the state didn't get hit with the need to stress or strain its social programs or its safety net programs. In Constitution, under the state constitution, it's prohibited to even impose a state income tax unless there's a 2/3 vote, which is going to make that very difficult to do. South Dakota always has a balanced budget, has for years, and that's also a constitutional requirement. Tax volatility. This is very interesting to me. There's a study by the Pew Charitable Foundation that looked at over 20 years all of the United States and ranked them from 1 to 50 in terms of tax volatility. And what that simply means is when states had to impose income tax, when they took them away, and it had to do with, of course, economic conditions. And going into the COVID crisis, South Dakota by far was considered number one, which meant it had the lowest tax volatility in the nation. And again, you might be wondering to yourself, yeah, okay, David, that's fine, but what does that mean for me? It means that when you're looking at states and you're spending money on attorneys and you're recommending attorneys and it's for your clients, and you finally settled on a trust jurisdiction, you don't want to put yourself in a trust jurisdiction that's ultimately not going to have a choice. They're going to have to start to tax trusts, or I guess put a state income tax in place. So that's why we spend time on this, and we look at these questions about debt and unfunded retirement costs. South Dakota has always been over 100% funded. Most states can't say that, particularly now. Always been a budget surplus. That's the case again last year by far. Second highest bank deposits. I think that surprises a lot of people, ahead of New York at 3.16 trillion. I know that's grown since I've done this slide. The overall bond rating has been AAA. That they received a AAA bond rating, they being state of South Dakota, right in the height of the COVID crisis, which to me was pretty amazing and indicated just how strong that state is. So I think that as we look at these factors and think about what happens when we make the determination as to where we want to be, this is a factor. It's a factor on the chart I'm going to show you, and it cannot be ignored. So now we're transitioning from how to use modern trust law tax arena legislation to benefit a trust and a beneficiary and a settler over multiple generations, and in some cases forever, as we talked about with the dynasty trust. But now we move into aspects of modern trust law that have changed over the last 20 years. And I love this because this quote is so true, is, there really has been more changes in the last 20 to 25 years and in the last 2 centuries. And we're about to walk into some of the most compelling changes. We now have asset protection trusts in the United States. We all know that in the old days, maybe 20 years ago, only asset protection you can obtain was by going to Nevis or Cook's Island or Bahamas or other areas. And we find that that's become problematic for lots of reasons. And we'll talk about that in a minute. Directed trusts, which I'm going to talk about in some detail. To me, I mentioned earlier, is one of the most revolutionary aspects of modern trust law that has set the stage to deliver a tremendous more direction and control back to families and their advisors than ever before. And in an environment of uncertainty, that becomes more important really now more than ever. Trust protector concept goes along with that. Another mechanism of tremendous control. Family advisor we'll talk about, which is like a trust protector light. Decanting is a modern trust law concept that has really changed the landscape completely in terms of how to move trusts, modify trusts, change trustee and change trust jurisdiction that did not exist when I was in law school, and is a whole other aspect of control. And then privacy, which has become wildly important to families, not only in the United States, but across the world. So domestic asset protection trust, what is it, and what are we talking about in terms of what a DAP is? What makes these so interesting and so special and so malleable and the ability to control them so well is that it's a self-settled trust that simply has a spendthrift provision in it. And now you might be wondering, all right, again, David, tell me why I care about that. Here's why we care about that. The example is a family or a physician who has $5 or $6 million that he or she is worried about being part of a lawsuit. The idea of asset protection protects assets inside of a trust from creditor claims, from lawsuits, from claims through marital, through divorce. And it's a very powerful tool. But the big concern for people has been, well, I don't want to give up control, and how do I get access to my money? Well, then, the self-settled trust was invented. Essentially how it works is the settlor is able to obtain or receive income, all the income, is able to get discretionary distributions, and does not lose control over very, very important aspects of trust administration and asset management because of the modern trust laws I'm going to talk about in a minute. So what we're talking about is a very powerful asset protection tool that is available, but without giving up the control and without giving up access to your money. And most states do not have a domestic asset protection trust. The top 4 generally have been considered to be South Dakota, Nevada, Alaska, and that's coming from Trust in the States magazine. It's very important to understand, as I keep saying, these statutes are all not created equally. Devil's in the details, I say once again. So you need to take a look at what really are the differences between these statutes. And really, the major consideration is something called a fraudulent conveyance. And fraudulent conveyance is really just a fancy way of saying, look back. And fraudulent conveyance is a presumption that after 2 years in South Dakota, the settlor did not settle this trust for nefarious reasons or otherwise to avoid a creditor claim. In Delaware, it's 4 years. And this is why the devil's in the details. If somebody wants asset protection but is not aware of an imminent claim, why should they wait 4 years to get it instead of 2 years? And so that's why when we look at these statutes, we have to pay attention to what is really the difference between and among them. And so that's something that I encourage you as advisors to be aware of and to compare. And I'm going to have a chart, as I've already mentioned, available to you. I'm happy to send it to you that really compares all of these concepts that we're going to talk about today, in fact. The Cleopatra case. I have to mention the Cleopatra case because it was such a big deal coming out of South Dakota a couple of years ago, and it really made the point that these spendthrift provisions that create the asset protections really do work. And essentially, it was a claim coming out of a divorce in California. California tried to enforce a judgment, and the lawyer tried to enforce a California judgment in South Dakota, and South Dakota Supreme Court said absolutely not. For various constitutional reasons, they would not pierce the trust for purposes of satisfying a judgment in another state. Very, very powerful, and makes the case of just really how powerful South Dakota's asset protection statute is. And I think it's one of the strongest, one of the strongest statutes in the country, particularly because of that case, or strongest case in the country. So now we're going to talk about trust structure for a little while, and really for the rest of the conversation today, because this idea of a directed trust I've alluded to it a few times has really, really disrupted the industry, and it's a concept that Bridgeford has embraced full-heartedly and believes in completely. And we believe it's one of the strongest attributes of the new paradigm that we've been talking about so far. And the concept is relatively simple. From a legality perspective, it bifurcates liability, which means that the asset manager is responsible for their activity and the trust company is responsible for its activity. And it bifurcates the roles and responsibilities. And ultimately, it gives the families and settlors of trust maximum flexibility around trust allocation, diversification, investment management, and distributions. So you're thinking to yourself, what do all those words mean? Or at least I'd be thinking to myself that. What it means is that it allows a structure, as indicated by this trust, to again, bifurcate what was bundled together in terms of liability, allowing a trust company like Bridgeford to emerge to say, listen, we don't want to manage money. We don't want that responsibility. We want the family to choose whomever they want to manage their money, right? And so unlike a situation when you go to a Bank of New York Mellon or Wells Fargo, when you go there, you don't have a choice. And fundamentally, people argue that that's a pretty large conflict of interest. So along comes the directed trust statute that allows the power to be put back into the hands, in my view, of the people who should have it in their hands, which is the family and the settlors, to choose who's going to manage the money, how the money is going to be managed. And that's the investment committee that you see there. Extremely powerful control mechanism. And again, I think really the heart of what I think is a revolutionary change in the trust industry, for sure. You have the ability to have a distribution committee, so the family can appoint people that they trust to make distributions. They can't be on the distribution committee, generally speaking, but they can appoint brothers and sisters or family advisors or lawyers or people they trust to basically do what they want them to do. I go back to the investment advisor, the settlor of the trust, or investment committee, excuse me. The investment committee member can be the settlor of the trust. He could be the sole member of the committee and can make sole decisions in terms of who manages the money and how. Again, those are things that were given up in the old days, in the old paradigm, and now they're not anymore. And that's thanks to the directed trust statute. The administrative trustee, that's where Bridgeford comes in, and we perform the traditional aspects of trust administration that's necessary, including distribution if asked. So as you can see, this model really breaks apart what was bundled before and delivers control back to, again, where I think it belongs. And then you add to it the concept, and you saw it to the left, and I'll show you again. To the left is the trust protector. The trust protector, we refer to it as a super trustee because it has, well, infinitely more power than the trustee itself. It has the power to control distributions. It has the power to modify the document. It has 23 different enumerated powers around asset distribution, asset management, and trust administration. When I say 23, that's South Dakota statute, which is by far the most expansive. And it creates a whole nother control mechanism with respect to trust administration. And the reason why this exists is really to provide another checks and balance. You know, we are able to move power and shift the power back to the family, which comes down to and includes, you know, who the trust company is, who the asset manager is, and that power resides in addition to the committee members we talked about in the trust protector. And so both concepts in combination deliver tremendous control and direction to settlors of trusts. And we embraced it at Bridgeford. We're not afraid of it. It should keep trust companies honest, knowing that a family member or an attorney in the stroke of a pen can remove us if we don't return a phone call. And frankly, I think it keeps the whole industry honest. It also keeps investment managers honest, and it keeps the fees normal, because if somebody determines it at that level, then they can replace any one of us in an instant. And so reasons why you see this, you know, I've already mentioned a few of them. You know, the idea to withhold powers is really important. Sometimes the trust companies go rogue, and not at Bridgeford, of course, and the trust protector has the ability to step in and address that. So we've talked about two probably not groundbreaking, but I guess game-changing. I don't usually like that phrase, but the trust protector and the directed trust clearly are game-changing elements in our industry, and have changed the whole world in terms of the fiduciary world. Family advisor, it's another great tool. It's called the Trust Protector Lite, and essentially it has limited roles. It's a non-fiduciary role, but also another control mechanism only available in South Dakota, I will note. So since it's only available in South Dakota, that drives a lot of families into South Dakota, because they may not have anybody who's willing to take on the responsibility of a trust protector, but they certainly are happy to have have somebody, or the person's happy to take on the role as a protector light, or trust protector, that is, because it's less responsibility. But still, there are things you can do that are powerful. You can remove or appoint a trustee. You can appoint a successor trust protector in that role. And you can do a few other aspects of control. Again, not not quite as expansive as the trust protector, but still enough control that makes the families feel more at ease. So I think from the perspective of modern trust law, what we're talking about now is sort of a scenario of decanting and how quickly and efficiently we can change a document. You know, one of the complaints about irrevocable trusts in the past is that they were so rigid and unable to be changed and sort of unmovable, if you will. That's not the case anymore in the United States, thanks to decanting. New York was the first statute to do it. And decanting conceptually is not complicated. Decanting really conceptually is basically taking an old tired trust and pouring it into a new trust with new dispositive provisions. Think of wine. When you decant wine, it's exactly the same concept. And it's such a powerful tool in conjunction with the other ones, because not only can we create a trust that has tremendous control and direction and asset protection, we can now take an old trust and add those same provisions, all because of the decanting statute, in my view, very exciting. So when to use them, you see them used to move, say, from California to South Dakota, more favorable trust jurisdiction. You can include asset protection provisions, as I've already mentioned, change to trustee, and a whole myriad of other powers that families really like a third party to have, that they trust and can control. Interestingly, you know, New York was the first to have it, but you know, these decanting statutes are not created equally, and we'll talk about that as we review the chart. South Dakota, for 8 years in a row, by a Nevada attorney, has determined that South Dakota has the really the best decanting statute, most flexible decanting statute in the nation. And which brings me to a very interesting question for me, because the issue is, do we have a duty to decant? Is there a fiduciary duty to do it? So for example, if we know definitively that we could have a problem with trust assets or asset protection issues, or we know definitively that if we simply move a trust into South Dakota, you can save money on income tax. Well, the question becomes, why didn't we do it if we knew we should do it, or we could have done it if there's something called decanting? And this case stands for that proposition. Is it malpractice? Will it evolve into a situation of statutory malpractice? We don't know, but it is an issue to stay on top of, and really, I think, underscores the real utter importance in our view of understanding modern trust law and the ability to do great things with it. You know, I think that privacy, I know privacy has become very important. Another extremely exciting aspect of modern trust law, driving activity into the United States and driving from all over the world. And it's an aspect of why the United States is such a target now for international families. There's something called a quiet trust and the court seal. Quiet trust, as you see, there's no disclosure requirement to children of the age of 18 or 21, unlike most states. South Dakota does not require that. And in court, the court seal in South Dakota, that is sealed forever, which basically means that information that could get into the public domain through litigation or a public docketing system, for example, will not happen because it's sealed in South Dakota. South Dakota has the strongest, by far, as pointed out by Trustee States magazine and other commentators. And Delaware has some privacy provisions, but not as robust. As you see, it's only a seal for 3 years. And it's discretionary. You have to convince a court that we need it and that it's necessary, and that is not always easy. And so where South Dakota really shines is in this arena. So I referenced the charts, and this is where we will sort of come to the conclusion and wrap up these various conversation around comparing trust jurisdiction. You know, as I've said multiple times, the devil's in the details, and as I've indicated, you know, there's nuances among the states. And so we took some time at Bridgeford over the last, frankly, 9 or 10 years to put together an objective chart that, as you see, cites authoritative sources of people smarter than those of us at Bridgeford, including Steve Oceans, who's a Nevada attorney, who, as you see, consistently has rated South Dakota the strongest and best dynasty trust state in the nation. Compelling, I think, because he's a Nevada attorney. He's also, as I said, made South Dakota the strongest in terms of decanting over 6 or 7 years, believes it's the most liberal. As I mentioned, South Dakota is one of 3 states that has a community property trust, very, very, very compelling planning tool. And, you know, you break down other aspects of what can be done in South Dakota. You know, the tribe privacy provisions, as I mentioned, are very compelling. There's a planning nuance only available in South Dakota, codified, called a special purpose entity, which gives even more control that we're not going to get into today. The family advisor and state fiscal health, as we had talked about, that has become so important, and South Dakota unequivocally has been ranked #1. So you might be thinking, well, David, you said at the beginning that you're founder and chairman of the board of a trust company, and you'll look me up and you'll say, oh, it's a South Dakota trust company. And maybe what I'm saying sounds very self-serving, and I don't mean it to sound self-serving. I mean it to sound objective, because it is an objective analysis. I think, and the final analysis, if we're being objective and we're just not calling our friends in Delaware or Nevada or wherever, and we look at the nuances, it's become generally held among many, many practitioners that South Dakota is the strongest of all the jurisdictions, which is why me and my partners chose South Dakota over Delaware and Nevada and Alaska. We could have gone to any one of those jurisdictions, and we chose South Dakota for a reason. And one of the interesting aspects of what I wanted to talk about, and I asked a question earlier, why Wyoming? Why is everybody talking about Wyoming these days? And I have to say, Wyoming is really amazing in terms of how they position themselves in the marketplace. When in fact, if you look at the chart objectively, in fact, most commentators don't consider them top tier. They consider themselves top tier trust jurisdiction. And I'm impressed with how they've gone to market and their hyperbole on that. But the reality is that they are not. And what they have hung their hat on, or the proverbial hat on, is this idea of an unregulated trust company, which is problematic and makes us concerned at Bridgeford and other jurisdictions, because essentially Wyoming offers the ability for a trust company to exist with no state regulation whatsoever. And from our view, it seems problematic, because why would a $500 million family want to have a trust company or a trust in a state that nobody's checking to make sure they're being administered correctly? The power of all this planning and the beauty of all of this modern trust law only works as well as the administration and the technical acumen of the trust companies to get this right every time. And that happens through regulation. And that happens through careful consideration of whether these trust companies are operating correctly and clearly. And so the unregulated trust company, where Wyoming has really carved out a niche to us, as I keep saying, is problematic, and I think not a reason to go to Wyoming, particularly since it's not even considered a top tier trust jurisdiction. So it's been a pleasure talking to you all today. I hope the program overall and the sessions overall have been enlightening. As you can sense, we have a tremendous passion here at Bridgeford around modern trust law and all the things that we can do today that we couldn't have done 20 years ago, that did not exist when I was in law school. And we love the education aspect of it, and we endeavor to make it as objective as possible. And in that regard, we certainly encourage you to look at our website. We have lots of educational materials there, lots of videos. We have a podcast where we've interviewed experts in the field from around the world. And there's multiple other webinars on there as well. Education is our passion, and serving large families around the country and across the globe is our mission. And we love to bring these concepts to the table. So thank you all again. I encourage you to ask questions. I look forward to the opportunity to interact. Certainly contact me or Bridgeford directly if you have any questions or if there's anything we can do to assist. And I hope the rest of the conference goes well.
Well, good afternoon, everyone, and welcome to the live question and answer portion of the presentation. My name is Trustee Faladori, and it is my pleasure to introduce David Warner. Please type your questions in the question and answer section of the conference platform. Questions will be read aloud for David to answer. So, David, our first question is, many people assume that Delaware is the best state for trust Situs. Which states may be better and why?
Thank you for the question, Trustee, and I hope everybody's enjoyed the last 3 days of programming. A lot of time and energy has gone into putting this program together, which appears to me to have been very successful. And happy to answer that question. And it's interesting. Back when I was a young attorney, everybody talked about Delaware. I have a partner that refers to Delaware as sort of an East Coast bias, or the presumed choice when trust planning is in place. And, for many years it has been. And it really is still a very good trust jurisdiction. I think as time has passed, particularly over the last 10 or 12 years, other states, particularly Nevada and South Dakota, have kind of pulled ahead a bit. And what I mean pulled ahead is they've been a little more aggressive in changing their trust laws in a way that is a bit more modern. I think if you look particularly at the asset protection statute and compare their statute, that is Delaware statute, with that of South Dakota and Nevada, you see some limitations out of Delaware, particularly with regard to what you call, and I mentioned earlier, fiduciary, or rather fraudulent conveyance, which is a fancy word, of course, for look back. In Delaware, of course, it's 4 years, as I mentioned earlier. And those other two states, it's 2 years. And there are other nuances about the asset protection statute that has become somewhat problematic. And, you know, even so much so that Trust in the States magazine has looked at Delaware, and every 2 years they do a really comprehensive comparison of top tier trust jurisdictions. And they've said themselves now over the last couple of years that if Delaware doesn't adjust certain aspects of its modern trust law, quote unquote, that it's not even going to be considered top tier. And I could tell you, even Steve Oceans, I've mentioned him a few times in his chart, and I think he has Delaware at 6 or 7 or 8 when compared to the other dynasty trust jurisdictions. So I think that, you know, optics matter and history matters, and I understand the historical reliance on Delaware trust law. I certainly understand the passion with which some people out of Delaware talk about Delaware in terms of its ability to be a great trust solution. I just think while it's good, I don't think it's the best option at this point for a couple of different reasons. South Dakota's privacy laws are far superior to that of Delaware, as we talked about earlier in the presentation. And again, there are other nuances that just don't exist at all. And so when we look at these jurisdiction comparisons, you know, and I offer the chart earlier as a real benchmark, you know, these are objective observations. These are very bright people that are making these comparisons, and encourage everybody to be very mindful of the details, because it really does matter in terms of these selections that we're making for trust jurisdiction.
Great. Thanks, David. Another question here is the trust protector a fiduciary role?
That's a great question. Well, it depends. You know, under South Dakota law, there is the ability to make it a non-fiduciary role, which limits the liability of that role, which is something that is pretty important to lots of folks. I think that the limiting factor, I think, of a trust protector or other aspects of fiduciary roles that I talked about earlier in the directed trust statute is sometimes people just don't want to take on those responsibilities. You know, that there's a lot of liability there. There could be a lot of liability. You could have an unhappy beneficiary who doesn't like the decision of the trust protector. So either under South Dakota law, the trust protector can become a non-fiduciary, which doesn't really completely, I guess, stop potential claims or lawsuits. But there's another mechanism under South Dakota law, though, that is worth talking about. I referenced it very briefly in this context, called a special purpose entity. And it's a vehicle that really only exists in South Dakota that I'm aware of, in terms of codified anyway. And what it does is it takes a fiduciary role like the trust protector and places it inside of a South Dakota LLC, again, only existing from a codified perspective for the limited purpose of serving in a trust as a trust protector. So, you know, for example, Justy, if you were going to be named as a trust protector in a document, you may say, well, that's a lot of responsibility. But I could say to you, well, Justy, we can create an LLC, and we'll call it the, you know, Justy South Dakota, Justy Special Purpose Entity LLC. That's what's named in the document, not you personally. And theoretically, that shell should protect you from personal liability and also give you the ability to get insurance if you want, which you can't do individually in those roles. And also the special purpose entity creates another touch point with South Dakota, which is becoming very, very important. Because, you know, we talked all about for, 45, 50 minutes about the power of modern trust law and the power of what we can do by simply selecting the trust jurisdiction. And that's great. But, at the end of the day, if these trusts aren't administered correctly, or if there's not enough touch points or nexus, as the courts like to say, with the states that I've talked about, then all the great planning and all the money that was spent and all the big ideas don't matter, because these trusts can easily be pierced if they're not administered correctly, or if it's determined that they're not really South Dakota Trust or Delaware Trust or Nevada Trust. And that's where, trust companies like Bridgeford need to have strong compliance, need to understand what is supposed to happen to make sure these trusts are real trusts. I think that's something we excel at Bridgeford for sure. So big ideas is part of the conversation. The other part is having tools like special purpose entity, trust officers that know what they're doing and understand the importance of maintaining proper jurisdiction from an administrative perspective. So it's probably a lot more than what that person was thinking when they asked the question. But the issue in my mind is if you're a fiduciary, you have liability. And if you have that liability, there's a mechanism in South Dakota to protect you.
Great. We have a question from John Wheeler. John says, great presentation, David. Are any compliance departments warming up to the financial advisors becoming trust protector light?
Great question. Thanks, John. Yeah, that's why I believe the trust protector, the trust protector light was the family advisor, which we're calling a trust protector light, was created. Yeah, and the answer is yes. We're seeing across the country where compliance departments for FAs, financial advisors, are okay with that role, particularly because it's a non-fiduciary role. And again, I think I mentioned earlier in the presentation that that's a major distinguishing factor because as far as I know, that only exists in South Dakota. So that's a great question. We're definitely seeing that movement. And again, I think it was created for that very reason. The thing about South Dakota, it's really amazing to me, and I'm a Northeast guy, as you could probably tell. They keep up, and every year they're changing and tweaking, and they have something called a governor's task force that had convened for years to give recommendations to the legislature about how to just be creative and be modern and be flexible. And it's to their credit that they came up with this concept called I keep calling trust protector light, but it's really the family advisor. Great question.
All right. And another question we have here is, if a domestic asset protection statute is funded in a jurisdiction with a 4-year look back, can it be moved to a state with a shorter look back period? And if so, will the look back period start over?
Yes, I understand that question very well. So essentially what the issue is there, and I talked about earlier, that asset protection statutes aren't the same in construction, and some have longer look back or fraudulent conveyance statutes. And so the point of this question for sure is, well, what happens if you're in Delaware, for example, and you started an asset protection trust and you said, oh, geez, I just realized that after 2 years in Nevada or South Dakota, my protection vests, if you will. And the question is, well, if I figured that out and my trust has been in place and funded for 2 years and a day, can I move that to Nevada or in South Dakota? Again, who have a 2-year look back, and those 2 years apply? Do we have to start over? And the answer is those 2 years apply, and it's called tacking, and it's pretty powerful. We've done that multiple times. In fact, not only does it work in the United States, it also works for international trusts as well, as long as there's a spendthrift provision and it's set up generally in the context of asset protection consistent with how we approach it in the United States. It works internationally as well, which is really an interesting nuance of South Dakota's law. I can't speak to if Nevada or Alaska or any other jurisdiction has that, but I know we have it in South Dakota. It works extraordinarily well, and really it kind of helps support the idea of making the proper trust selection in the planning process. Asset protection, whether it's controversial or not, or whether some say it's, although while we have that debate, there's still not a case on point that says they're not enforceable. The reality, though, is if you are interested in asset protection and you don't have a pending claim against you, and you have no reason to believe that one's about to come to you, why not go to a jurisdiction that has the smallest or shortest look back period and has been rated among the top? And that's where I think, we worry about, back to my point earlier about Delaware. And, from that perspective alone, while I respect the people in Delaware who talk very loudly about how powerful that jurisdiction is, that asset protection weakness is real. And I think when somebody wants asset protection, they want it in 2 years, not 4 years. So that's another great question.
Looks like we have a question here from Drew. Drew asks, does both the financial advisor and trustee have fiduciary standards?
Great question, Drew. Thanks for the question. And I think the answer is absolutely. I think that I know advisors like you, Drew, in particular, take that very seriously. We have some advisors that don't consider themselves or operate as fiduciaries, but I think that's sort of a dying paradigm, again, old versus new paradigm. So while there's fiduciary duty on the part of a trustee that's specifically defined, under codified sections, both in the Uniform Trust Code and other places. Certainly, fiduciary activity on the part of RIAs and other asset managers. I'm sorry, I meant to say asset management and planning activity is certainly operating in a fiduciary capacity, a little bit differently defined. But again, Drew, I know that you take that seriously, so I appreciate that question.
So it looks like we still have a few minutes here if anyone else has any more questions. In the meantime, David, is there anything you would like to expand upon or add to the conversation today?
Sure. Well, first, I want to thank you all again for the opportunity. I know this is a very well thought out and planned event. I think as we close out, unless there's another question, I would certainly encourage people, and I may have mentioned this before, to look at our website, not just because I want you to know all about Bridgeford, but there is a lot of education material on our website. We've spent a lot of time building our blog series. We have a podcast series that is very, very, very successful. And the whole focus is on objective education and really getting into the heart of modern trust law and what's available. And, while I've spent a lot of time extolling the virtues of South Dakota, which I understand, as I said earlier, may sound a bit self-serving, the reality is we live in really exciting times in the trust space. I wouldn't have believed this to be the case when I was in law school back in the late 90s, but this really is a dynamic time. It's a dynamic time for advisors like you to work with trust companies like ours to remove conflicts of interest and to serve families in a way that they deserve to be served, in my view, which is to deliver as much direction and control as possible. It opens the door for, tremendous advisors like Drew and a Bridgeford Trust Company to come together and do great things for a client. And that did not exist back when I was in law school. And that's a very exciting evolution for all of us. I think we're paying attention to the old versus new paradigm.
All right. Well, I'm not seeing any more questions here, David. So I'm going to turn it back to you to close us out and bring us home for the afternoon.
Great. Well, again, congratulations to you all on a sounds like a very successful conference. All the planning that went into it, I know, was very intense. I could tell you this is the most prep I've ever done for a conference. So congratulations on making me do this correctly. But all joking aside, I hope it was as beneficial for everybody as I know it was planned to be. And congratulations again to the group on putting together such a great program. And it's been an honor to participate.